Hey, everybody, and welcome back to the Legal Weekly Wine, where we talk about the week's hottest legal topics. We are on fire. This last week of June has brought down a number of very big, strong cases from the Supreme Court. So we are doing a Supreme Court case review. We've now had two episodes that we've done. This is our third episode just on this last week of June. So we've done the debates. We had to do that by itself. We didn't think we would, but then we did. So do check out that video. I believe the title we've put on there is, well, that was embarrassing. So check out that video. We'll have it in the links and ready to go at the end of the program. We also have a video that we've done for 3 of the Supreme Court decisions that came down. That would have been City of Grants Pass, Oregon, related to homeless encampments. It would have been the Loper-Bright decision regarding the Chevron case, as well as the Fisher decision for the January 6th riot case. So check out that video if you want those cases. This video is going to be on the Idaho abortion case, that's Moyle. There's going to be the social media case of Murphy versus Missouri and the opioid case of Purdue Pharma. We will also do a comment or two on the Drummond case out of Oklahoma, their Supreme Court regarding state aid to Catholic schools, as well as the AG's announcement in California of that there has to be teaching of the Bible, a mandate from 5th through 12th grade. So we're going to talk about all of those things today in this episode. The next episode, normally we post once a week. We are doing multiples this week because we cannot go without what's coming next, which is the presidential immunity case. So stay tuned for all of these episodes. Like and subscribe to make sure that you get all of them. Go back. If you can't find them, go back and look through our playlist for the Legal Weekly Wine and join us as we continue on the Supreme Court review. I'm Virginia Tarani. I am the owner and attorney for Tarani Law, LLC, because you never need a lawyer till you do. We practice in Maryland, D.C., and Virginia, and I'm also the CEO of The Law Unscripted, which is the company that hosts the Legal Weekly Wine podcast, the Law Unscripted podcast, and a set of core subject matter reviews for the 8 core subjects of law school. That will include bar preparation material as well as law school exam material on those 8 subjects so that you can supplement. Chelsea Rogers is my co-host, and she is also an attorney with Tarani Law, as well as our co-host for The Law Unscripted and the Legal Weekly Wine. She is here today supporting the law students as they go through their bar preparation this summer with our fantastic hat supporting her alma mater. Tell us about it.
Yes, so this is American University Washington College of Law. It's where I graduated from in 2023, and I'm always happy to rep some merch. So this is from the campus bookstore. I love it. But yeah, I'm glad to be here. We have a lot to talk about.
We do. Well, thank you for joining us. And Dr. Vial is with us. John Vial, he's the Dean of the Honors College for Middle Tennessee State University. He's a political scientist who is an expert in the Constitution, constitutional law, the amending process, and clearly politics in general. So we're thrilled to have you here to help us review the Supreme Court cases as well as some of the politics that are happening out there right now. Thanks for joining us.
It's a pleasure. I always taught constitutional law in fall and spring. Mm-hmm. And I wish that I were teaching a constitutional law class where you just say in the last 3 weeks, we're going to do just what we're doing here. Yeah. Each week, we're going to read the opinions from there and we're going to discuss them. And if I could just put in, pardon?
What a unique idea. You should do a summer school class like that.
Well, I would sign up to take that.
I wanted to bring up something from a case the last time for just a minute.
Please.
This Loper-Bright case, which dealt with the Chevron, they overturned a decision that went back about 40 years or so. I think we've talked before about stare decisis, which basically means to what degree are you going to accept or not accept precedents? And I have not seen, the classic text for this is one of the, and I don't know why I can't call it, I believe it was the Casey decision, where the court public opinion had turned a bit against Roe versus Wade. It wasn't clear on the court how many people would have written the opinion if they were still there. And three of the justices got together, one of whom was Justice O'Connor. I believe it was O'Connor, Breyer, and I'm not sure who the third was. But in any event, basically said, we're going to adhere to this because we put a lot of time and effort into deciding Roe. It seems to have worked in terms of creating a viable standard. And this decision is very similar, only you have an argument from both sides. You have the majority opinion who's overturning a precedent, basically saying, we believe in stare decisis, and they have a long analysis of sort of the history of stare decisis and when it's appropriate. And what they basically argue is that this decision from the beginning has never really worked. And one of the more unusual arguments is we haven't applied it since I think it's 2016, so we haven't applied it in 7 or 8 years. And then the dissenters, who are generally liberals, the three liberals on the court, who, you might think, if they'd been on the warring court, they would have been arguing for overturning precedents.
Sure.
Basically saying, not so fast. And one of the arguments they say is you can't ignore a decision and not apply it for 7 years and then say that you don't have a precedent here. And you had something similar in the Kennedy case, the case that we talked about prayer by the football coach. The court can say, well, you applied the Lemon test, and so we ought to overturn it. But the other thing is, well, you should have been adhering to the Lemon test until you did overturn it. But one of the fascinating things about this, I don't think I've ever seen this said in a court decision before, and I don't have it marked, but one of them says, we have put a tombstone on to mark the demise of the Chevron decision. They didn't leave any doubt. They didn't just ignore it. They said, it's dead. We're not going to apply it anymore. But if particularly law students were interested in, sort of the arguments for and against stare decisis. And of course, the arguments are rarely divorced from the specific issue.
Right.
We all want the court to stick with decisions we like and overturn the ones that we don't. But, you expect the court to reach a little bit higher level. And one of the things that I think neither side emphasized enough is under Chevron, the court was deferring to decisions by administrative agencies, even when they flip back and forth. And the court said, law is supposed to be steadier than that. Sure. And they're reacting to what I really get upset with, that every new president, they're doing more and more by executive decrees, executive orders. And that puts us, a lot of people say our system of separation of powers is better than parliamentary systems, because in a parliamentary system, every time you switch leaders, then you switch policies. Right. And I think probably the strongest argument that was unstated in this case against Chevron is that it has led actually to legal uncertainty rather than legal certainty. But anyway, just a footnote to our previous discussion.
I appreciate it. So if you want to hear more of the discussion of the Chevron case, check that podcast out. That one is immediately before this one. At the end of June, it will be published. The first week of July is when you will see it coming out. So check that one out for a further discussion of the Chevron case. We're going to get into, I think I want to start with the Idaho abortion case next. But before we do, it is the weekly wine. We are drinking a lot more than weekly right now with these podcasts. But, it's some good wine. I'm finding some good ones. I'm not sure how this one is going to taste. I have got something called Purple Bird. It's a really cute little label. I know we're not supposed to just choose on labels, but there's a reason there's a lot of marketing as to what the labels look like, because people are drawn by what's pretty to their eyes, what's eye-catching, the titles. But this is Purple Bird, and it's a cab, but it's cute because it says, international lovers of wine will go crazy for this little red claret, featuring more than a kiss of Cabernet Sauvignon. So it's really cute. It's got plum and raspberry, creamy texture is supposedly what it is. It's a South Australian wine, and I'm looking forward to it, especially since purple is our color. Chelsea, what have you got?
Okay, I'm excited. And this is how you know we're on the same brainwave because I was gifted some wines and I've had a selection to pick from. But today I picked the one with the prettiest label also. That was how I selected this out of our gifted
Nice.
wine. This is a Moscato, which everybody knows is kind of my jam, anyways. But this is a fancier Moscato than my normal grocery store choice. It's Vietti. And that's it. Everything else is in Italian. So that was my best bet. But if you guys want to take a look, it looks delicious.
Yes. Send me a text
So
of
we
the
will
label
see.
and we'll get it up and make sure that we
I
have the
will.
right name in our description below.
Yes, I'm excited to try it. So we will see.
Very nice. And Dr. Vile?
And hoping that your wine does not boomerang on you, I am back to my standard Pepsi.
Very nice. Okay, so we've got the caffeine going by Dr. Vile. Cheers, everyone, and let's get started. Ooh, and the little purple bird is quite delightful. I highly recommend that.
Tweet.
I can actually taste the plum. I feel like I'm eating. Dr. Vile will appreciate this. He's my father, and my grandparents who lived in Luray, Virginia. While we were growing up, they had plum trees, multiple plum trees, and a lot of my childhood memories are on their property of eating the grapes on their vines, the cherries in their trees, and the plums. And I can't tell you how many times, I stepped outside to smell the plums in the air, and that's how I'm feeling today. So what a nice memory. Very nice. Though I highly suggest, as a lesson learned as a young child, not to eat too many plums at once.
Yes.
That's my tip of the day.
It's like little green apples. Similar effects.
Very much so. All right. So, Dr. Vile, let me start with you. We've got this abortion case out of Idaho, and we've had a lot of abortion cases lately. We had Roe versus Wade was overturned with the Dobbs decision fairly recently, within the past couple of years. And now we've got this trickle of cases of now that the abortion cases are back to, or the abortion decisions are back to the states. What can the states do? How far can they go on their own to allow abortions or to prevent abortions? And so we have the singular case from Idaho about emergency abortions. Can you give us a little background as the specific facts of this case? Because it is a broad application since it's a Supreme Court decision, but we're going to be asking in the end, how far does it go? How much did it actually open the apple cart back up?
It's a pretty limited decision. And it does suggest, the whole issue suggests that what the court tried to do in Dobbs may ultimately not work, in the sense of, even if you turn it back to the states, you're going to probably have some policing of outer boundaries. And, one of them, we've already had a decision earlier about, FDA regulations regarding abortifacients.
The pills.
And almost surely we're going to get decisions as to whether states can penalize someone who goes to another state. I think they can't. I think that right to travel would cover that. But this decision it's a potential state and federal clash. Federal law says, as I understand it, that hospitals that accept federal aid, and almost all of them are dependent upon it, that they cannot deny someone emergency treatment in cases that directly affect their health. And as I understand it, Missouri has a law, not dissimilar to others that have been adopted, which say the only exception that we're going to make for abortion, emergency or otherwise, is in case where the direct life of the mother is threatened. So we've had a number of cases in Missouri, Texas, and elsewhere in which a woman comes in, possibly bleeding, having contractions, and it appears as though she probably won't die as a result of it, but she may lose her fertility, or she might suffer other damage. And the question was, which rule in a case? And so the federal rule says, in the case of the health of the mother, you have to be able to provide emergency abortions in facilities that are aided by the federal government. And Missouri says, well, that's all well and good, but we don't permit an exception except in the solitary case of the actual life of the mother. And the court, I think unwisely, issued an injunction basically saying that the Missouri law was going to remain in place, which it did for the last 6 months or so. And if I understand the situation, there were numerous cases, or at least some, in which the state of Missouri called in a helicopter from another state and said, we can't perform an abortion. We believe this woman needs it in order that she not lose her uterus or whatever. And the court withdrew its injunction against the federal law here. And so in Missouri, for the next however many months till this is decided, the state can continue to give abortions, or doctors can, without fearing prosecution for the health of the mother. Now, the state is concerned that the term health of the mother could expand to cover everything. Somebody comes in, as I probably would if I were pregnant, and say, I'm really depressed about this.
Yeah, you would think.
Right.
And I think they're afraid there's a slippery slope that doctors will begin and patients will begin to exploit this loophole, which is designed primarily to protect serious cases from anybody who says, well, being pregnant is giving me a headache, or that sort of thing. So
Right.
It's by no means resolved.
Now you're mentioning Missouri, but
Yes.
is this not from Idaho?
I'm
this
sorry, it
particular
is from
case?
Idaho.
Okay,
Yes.
I want to make
My
sure
apologies.
we clarify. No,
And by the way, so we can also clarify here, the Bible reading case comes not out of California, but Oklahoma.
Okay,
So,
good. Thank you for the clarifications. Wanted to make
no,
sure we were
it is
all on the
Idaho.
right
And
page.
I love Idaho because it's a made-up name. When the state was admitted, the guy passed it off as an old Indian name, and apparently he just made it up because he thought it sounded good. So I like that.
Okay, so Chelsea, have you? I know you have a lot more in-depth review and research based on your law school career of the abortion cases. Is that right?
Yes. Yeah. So my project, or I don't know what they call it now, but it was essentially like my capstone. I had to do a really long paper. That was torture. That was the worst project of my life. But I did it on how we got up to the Dobbs decision and the kind of political and social, a lot of the time, cultural changes leading up to Dobbs, which was really interesting, specifically with evangelicals. So it was kind of a really narrow project, but I read a lot of these cases. I thought this was creative lawyering again. The idea of using EMTALA to get an abortion case to the Supreme Court, I thought was creative. I don't know if I would have thought of it, because from my understanding, and please correct me if I'm wrong, because I didn't know what EMTALA was before this case, but it's essentially the stabilization of people at the emergency rooms, right? And you wouldn't think that has anything to do with the abortion conversation, especially because EMTALA is old. This is not a new thing. So I think it's creative lawyering. And I think it's interesting how so many of the justices were so split. We got tons of opinions on this. Basically, everyone was split off in either a concurring or dissenting opinion.
And Alito particularly had sort of a really, look, we made our decision in Dobbs. We need to stick with it, come hell or high water. I don't know why the rest of you are so weak-kneed, basically was his opinion.
And what was the breakdown? Was it a 5-4 decision? What was the majority?
Well, it was a per curiam opinion, which means you have a majority. And then you have 3 justices who write concurring opinions. And then Alito's dissent is joined by Thomas and Gorsuch, at least in part.
And for those who don't know, what does per curiam mean?
Well, it's basically, let me read it to you. The writs of certiorari before judgment are dismissed as improvidently granted, and the stays entered by the court on January 5th, 2024 are vacated. So it is so ordered. So curia is a group, like the papal curia that chooses a new pope. So it's an unsigned opinion on the part of the court majority.
Okay. And what does it effectively, what's vacated? What's vacated and what does that do for us?
Well, the court, as I understand it, the Supreme Court had issued an injunction against application of the federal law in this case, thinking that it would I think their thought was that it would not prevail because Dobbs had basically sent this decision back to the states. But you still have a potential conflict here of federal and state law. And usually when that happens, the supremacy clause in Article 6 kicks in, that federal laws are superior to those of the states. But again, I think it shows the I don't know that anybody, when they decided, I think a lot of people when they decided Roe versus Wade thought that would be the end. And no, there were dozens of cases that does the husband have to give a consent? Can what about a teenager? Can you tell them the consequences of abortion before it happens, et cetera, et cetera, et cetera? And my fear is that Dobbs is going to be the same, that we might end up with someplace between Dobbs and Roe before it's over. And of course, just technologically, one of the big differences, as I understand it, and Chelsea will know better than I do, but I believe it's now about 2/3 of the abortions in the United States are as a result of taking medication.
Yeah, it's a significant majority.
Surgical procedures. And part of that, which arguably is a result of Roe, is Roe basically made it far more permissible to have abortion in the first trimester than later. And so, to the degree that this is caught on, it means you're less likely to have state interference. Again, unless now there are some states, and I can see the argument, we've outlawed abortion in our state. We value human life here, and we don't want somebody, this is the same as getting a loaded gun through the mail. We don't believe somebody that should come through the mail, but I don't think they're going to win on that.
Yeah, I think it's interesting. I'm in one of those states, so I'm in Georgia, where it is perfectly legal to go buy a gun and have no proof of it. In Georgia, there's gun shows every weekend within 45 minutes of me. I can go buy a gun. There's no proof of that. But it's the 6-week heartbeat bill is what they pass. So it does seem to me to be a little bit of a contradictory idea of how we're legislating. But the argument you're making of that this law is preempted by federal law is what Justice Kagan wrote. That's what her opinion was.
Right.
And that was joined, I believe, by Sotomayor and partly by Jackson, was that this has been preempted already.
And that preemption then means, and I'm going to make sure we've got this crystal clear, is that the emergency abortion is available based on this decision. Of Idaho.
Would we say Idaho?
Yes.
They have not. I think they've limited it to that case.
Yes.
And the problem with this is when you have laws that you're not sure whether they apply or not. Okay, think of yourself. I just went to a ceremony for people who just finished their medical residency. And what is this? Are you going to take here's a woman in great pain. Perhaps, bad harms to herself.
Right.
But if you perform an abortion and the state later considers it murder, you might go to jail. Right. And so it's, that's when you call the helicopter from another state. But, if you think about it, a woman could die in the process of getting there, depending on the seriousness of the situation. So I read an interesting article, I believe it's by David French, who I admire a lot, who he's basically, as I understand it, pro-life, but he believes very strongly in the exception that we have in most criminal laws. I'm pro-life, but if I have a gun and someone is coming into my house to kill me or to rape my wife, I'm going to use lethal force if I need to use it. And it's not because I don't believe the person coming into my house has dignity. It's just that I also believe in one of the commandments that says, "Thou shalt not murder," and I don't want him coming in and murderizing me.
Right.
And of course, Missouri would say, "See,
Idaho.
This is where I think the pro-life movement has."
Idaho.
Well, where the pro-life movement has gotten off track is they're coming across not as loving children, but as hating women. And,
Oh, interesting.
there are some things, I mean, I would consider it, potentially, if a woman sacrificed her own life in order to bring a child into the world, and she was doing it consistent with her beliefs, I would say that's a noble act, but I don't expect the law to enforce that kind of nobility on most people. If there's ever a time for a choice, and you have, if she does that at the cost of leaving behind 4 children who need her care, I think I think there are places where reasonable people can say this far and no farther, just as there are for self-defense.
I absolutely agree with that. I think, and a lot of these things in statistics, a lot of the women who seek abortions are already mothers or are under the age of 18. Like that makes up a huge demographic of the people who are seeking abortions. I also think this is just generally, I don't want to make that call for anyone else. Just, there are a lot of people who choose to become parents that are in a lot of different situations that I might personally find immoral or that I don't necessarily agree with, but do they want me enacting their ability to have children? I think that is just a decision. I would never want to make that call for anybody else. And I also think what I find really hard, it's interesting because we're talking about Chevron, this the idea of pushing these things to agencies because they're experts. I have a really hard time with these cases when we have people who are not doctors, who have never worked in the medical field, trying to split hairs on what the medical cutoff in these type of situations should be. And I think that rubs me the wrong way. I'm not a medical expert. I would not want to write something, making a call medically.
The area where this is, and we haven't discussed it, but it's very important. A lot of laws right now or a lot of states are adopting laws against hormone blockers or surgeries designed for trans.
Right.
And I'm conflicted on it because I believe it's very difficult to make a permanent decision, particularly about one's body, before one is mature enough to be able to make such decisions. But typically, I would say that I think that parents probably are in a better position to gauge the needs of their children than are the state government or state governments. And what's interesting is I read an article just this last week, World Magazine, which is sort of an evangelical Christian publication, and they interviewed a lawyer, and you guys can think about this, who is specializing in people who he claims made the transition and then were sorry about it. And he is planning to sue doctors who permitted these and counselors who gave advice to young people, let's say to have their breasts removed or that sort of thing. And it's an interesting approach, but partly it shows us how we're really not that far along in terms of medical knowledge.
No, right.
In terms of we don't know necessarily what the effect of making a transition at the age of 14 is, as opposed to someone who does it at the age of 30 or 40 or whatever. And I don't have the answers there, but there are some similarities.
Yeah, I think a lot of these questions are interesting, especially because I tend to be very libertarian. I'm I don't want the government. I wouldn't personally want to make this choice for anybody else, or if this was not my child, I wouldn't envy a parent in that position trying to make these choices. And I don't think there's a way to legislate it fairly. I had this discussion the other day when it comes to sterilization procedures. There was a little bit of an uproar on it on social media about people thinking that they were going to allow teenagers to sterilize themselves and what that conversation is. My mom and I have very different opinions on it. I was I've always known I didn't want children. I knew that at 13, knew that 14, knew that at 15. I will be 30 next year.
Usually you don't find that out till after you have them.
Right. But even as an adult at 19, I went in and was can I get sterilized? And doctors wouldn't even do that. I was fully an adult. I was in college, and doctors wouldn't do that for the fear of, I'm afraid you're going to change your mind down the road. And so I think a lot of
and
these
maybe
situations.
Sue me. Yes. They're not giving me good. Then that goes back to this case that I told you about. They're going to be fascinating cases.
Yeah.
Yeah, I feel like it
Whatever
has to
you
be such
think.
a small percentage, though, just statistically of like
Yeah.
people who had this done, the people who then regret it and then are
Right.
going to pursue it. I mean, I'm going to be interested just to follow that and see where it goes.
Yeah.
Definitely. Okay, so let's transition really quickly. Let's do another medical case. So at least we're in the same ballpark with transitions. Let's talk about opium. Normally, we're thinking for the opioid base, we're thinking of heroin, actual opium, morphine, a lot of prescriptions now, right? We've got oxycodone, oxycontin, hydrocodone. We've got all of these all of these have a base of an opioid. And we've gotten a lot of traction in the last number of years against pharmaceutical companies for the production and supply of opioids because there's become a mass epidemic, quite frankly, of overdose deaths based on opioids. I definitely saw this a lot as a prosecutor. I dealt with a lot of drugs, guns, and gangs, those types of cases. And I remember when I was in Winchester, Virginia as a prosecutor, we were coming up with a lot of overdose deaths, and it was the first time that I had heard that there was a consideration of do we have Narcan given to police officers. I clearly remember this discussion, and now it's, everybody has it. But at the time, the question was, could police officers even use Narcan? They weren't paramedics. They weren't part of the ambulance crews. They weren't doctors. Could they safely
Does it bring liability on you for doing any of that?
Exactly.
And now they give it to librarians.
They give it to librarians.
In some cities.
Exactly.
You can go pick up free Narcan and to carry around just for your average person.
Right. So 10 years after we started these discussions in the office where I was working as a prosecutor, now it's freely available. And the idea is let's save as many lives rather than worrying if we're going to kill someone with this life-saving drug for overdose deaths. But many, many families have been affected by the disastrous results of opioid addictions and specifically prescriptions. And that's what's happened through the industry. And we've got this case now in front of the Supreme Court, which is a weird issue. As I was like, oh, it's an opioid case. Surely it's going to decide something about drugs and, whether they're available to other people, whether you can criminally prosecute them. This is where my mind is headed. But it's
bankruptcy court.
Bankruptcy case. So that's why I've pulled this one out, that I think it's worth, a few minutes of mention to discuss why in the world are we doing this Harrington versus Purdue Pharma. What is this case about? It's an opioid case. It's resulting from the opioid crisis, these deaths that are occurring. What does this case mean that it's a bankruptcy case? How will it affect people? And does it make an actual change for this opioid crisis? Do either of you want to take a start at this?
I can do it if we need.
All right, Dr. Vial, let's have you start.
It's a brief summary, but essentially, the opioids, as I understand it, were for a time marketed as a perfectly safe, non-addictive painkiller that should surpass anything. And apparently, long after reports were coming in that it was one of the most highly addictive drugs out there, what do you call pharmacy? Pharma, yeah. Pharmacy, which is largely owned by the Sackler. Is that right? Or Sackler?
I can't.
I believe it's Sackler.
Yeah.
This is a family that, was sort of behind this. As I understand it, they withdrew approximately $12 billion out of the company before it was finally sued in court and made the subject of bankruptcy proceeding. And so then the question is, how are you going to reimburse the states or the individuals who lost loved ones as a result of this drug that should never probably have been? I don't know if there was no use for it, but there's clear evidence that it was over-marketed. It was definitely marketed as something that was not addictive, and it's highly addictive. And so what the lower courts decided, the the Sacklers said, we're willing to give, I believe it's $4.3 billion
Yeah.
to help this bankruptcy settlement. And a lot of states, they're like the smoking thing, they're not going to give it back, I fear, to the people who need it, but they claim they're going to use it to, stop opioid addiction and treat people and whatever. And so they enter into a bankruptcy agreement. We'll give $4.3 billion, but in return, we want immunity from criminal prosecution. And this gets to the court, and the court says, you can't make that agreement with the Sacklers unless you have the consent of the other people involved in the case. And the sad thing is, this means some other people in the case are not going to get their money as this goes on for another however many years. Right. But there's a certain logic to it. Who's being left out of the discussion? Well, the people who have suffered the most, who have lost loved ones. And some of them feel apparently very strongly that if anything ought to get you in jail, it is marketing. Think of them, if we didn't call it Narcan, not Narcan, we didn't call it whatever the drug is.
Oxycontin.
Oxycontin.
Yeah.
If we called it heroin or we called it opium, what would their sentence be if they had marketed this as a recreational, non-harmful drug? Well, we put them in jail for life. Mm-hmm. And so some of them are saying, great. They took out $12 billion, they're giving back $4 billion, and you're not even going to send them to jail? I sort of get it.
Yeah.
And also, from my understanding, this agreement shielded them from the family, not the company, from any future lawsuit. So not even just criminal prosecution.
That's probably a more important point, maybe.
To me, that's a deal right there. Obviously they're paying out billions of dollars, but the idea that you can be shielded in the future from civil responsibility, I've never heard of anything like that. Virginia, this is unheard of, I think, is my understanding, that they don't have the authority to do that. You can't take away what is potentially an unlimited class of people's right to sue somebody.
That's my understanding as well. And I'm going to relate it to the asbestos cases. Yeah. That's what I'm going to do is from
mesothelioma, right?
Mesothelioma.
Yeah. Do you have courses on that in law school?
I actually, that's funny. It is, it's a mass tort. It is part of torts law, civil procedure, civil liability. I actually worked as a law clerk for someone who was dealing with the asbestos cases, the mass tort cases. So I know probably more than the average bear about these cases and about the history and the reports. There was a significant report that came out in 1984 on asbestos that was covered up. It was, they continued to market products, produce products, use products throughout all the industries, and the ones that hit most were those, in roofing companies, in the automobile companies, shipyards, and it's this mesothelioma that nobody had seen before. And there were these reports of, hey, there's a direct correlation of significant disease from asbestos exposure. And now all of these people are getting sick, and we had so many companies, including Owens Corning. That was one of the companies. And ultimately, how many of them declared bankruptcy? They filed the Chapter 11 bankruptcy of, we don't have the money to support all of these lawsuits. We still see it's not as prevalent anymore because most of those who were exposed to asbestos have gotten older or who have passed. And we aren't using asbestos, thankfully, anymore. But the idea is those victims still were able to recover. How many advertisements out there from lawyers of have you, do you or a family member
or a loved one
have you been exposed to asbestos? This is decades long where there was no mass settlement that says these individual victims who find out later that this has affected them
are barred from recovery.
They still can recover. all these years later, now there's a trustee involved in things.
Yes.
There's different portions and apportionment that is made. But I think it very much like the asbestos crisis of all of these victims. Why I think the court made a good decision is why would you cut off their rights? And some people are saying, no, you've prevented us from collecting. But in my mind, I think it goes to the no, overall, we're allowing the rights of every individual who has a possible claim to still bring them. Yes, they're still in bankruptcy court, but there's got to be another resolution, and you can't sign off, like Dr. Vile's saying, without all of the signatures, without all of the victims' consent. There are certain, in Virginia, there are certain laws that prevent prosecutors from making a plea deal without consent of a victim.
Or at least consultation.
Exactly. Right? At least consultation where you have to, my signature was my oath, essentially, that I had consulted with the victims before entering this decision, before offering this plea. So I think it's fairly consistent with most state laws as to tort litigation, civil claims, which is tort litigation, as well as criminal procedure, as who is available. Can they really make this one mass sweeping decision that will affect the rights of hundreds of thousands, if not millions of people?
And this ties into Monday's case.
Yes.
Are you going to give immunity to people who headed these organizations and pushed false notions and just say it's all under the bridge?
Right.
Do we want whatever guards we want to protect presidential decision making? Do we want to put presidents in a position where they literally can go on the street and shoot somebody and they're immune from prosecution?
Right.
I think not. We'll see what the court says tomorrow.
I mean, I think what is so abundantly clear to this of the fact that they were willing to sign a deal where they owed $4 gazillion, billion, I think it was, $4 billion,
4.3.
right? The fact that they were like, yeah, we'll sign that if you sort of protect us, just tells me they are also clocking the fact that would be a huge win for them, right? Like, I mean, what would it take for you to agree to pay some $4 billion, right? I think they are very aware that if this didn't stand, which it has not at this point, that they will be sued for the rest of their lives. And I think that's probably fair.
And I do too, based on the asbestos litigation that's been massively litigated in this country. Cigarettes. I mean, that was phase 2, right? We had asbestos.
Yeah.
We had
baby powder. It's been
cigarette
the most
companies,
recent ones.
baby powder.
I got an information for
Mm-hmm.
a class action lawsuit. Literally 2 months ago, it was about an eyelash serum I had used. And I'm not kidding. Apparently they falsely advertised the possible side effects. I had no side effects. It worked fine. But apparently some people had it and they knew about it and had never put any warnings, advertised anything. And so got a little card in the mail that was like, you actually are owed money for this company who falsely,
Fraud is an exception to First Amendment protection.
It is.
Yeah.
First Amendment does not give you the right, particularly in marketing. Now, it gives you greater rights in marketing political views than it does medical products.
Yes.
Maybe it's backwards, but nonetheless.
But even as attorneys, we have ethical rules as to how we can market and advertise ourselves. So I think
that's not an oxymoron.
Right.
Ethical rules for attorneys.
It does feel like it.
Okay, right. Political scientist. Sorry about that.
No, so as much as, and I do sympathize with victims who could, if they entered into this bankruptcy decision and agreement, who could get paid more quickly and more money, that I do recognize that it is a disappointment for them. But I think in being consistent with our prior rulings on asbestos cases, on cigarette companies, and other manufacturers of products that have been very harmful to our citizens, I think that this is consistent, kind of stare decisis type of issue.
And by the way, one of the specific powers that Congress has given in Article 1, Section 8 is the power to do a uniform rule over bankruptcy.
Yes.
So it's a federal domain if they exercise it. Now, they went almost 100 years before they did
Anything, right?
Well, one of the justices said exactly that. And that was a quote. I don't know which justice
So
I
one of
think
them
it
read the
was-
Constitution. That's good.
I mean, right, we're off track.
At least one of them. I like that.
Yeah. Oh, I think it was Gorsuch. He said,
Okay.
our only proper task is to interpret and apply the law as we find it, and nothing in the present law authorizes this discharge. And
Right.
he goes on to say, if you guys want that,
Right.
talk to Congress. Don't come to me about it, essentially.
Right. Let's put it back on the power that, or the group that has that power based on the Constitution, the
I
separation.
mean, I have a hard time, and maybe because I'm not imaginative enough of like, if we allowed this, I think every big company that gets sued for doing something scandalous like this would put that in there and wouldn't agree to anything unless it was put in there. And then how does that work for everybody else? I think all of the sort of the Aaron Brockovich of it all, of like, what happens to these people if, they're not aware or not
Just
tuned
in the
in.
last week
Right.
or two, this train wreck that occurred in Ohio, there's renewed questions, and I don't know the truth of the matter here, but the renewed questions about the current, the allegation is that the company knew that the train cars were not in danger of exploding, and they nonetheless ordered them to be burned off, and that affected health in a way that it wouldn't have had the company shared the information that they had.
Right.
And that,
Right.
that's not only wrong, that is criminal. If you're
Yeah.
putting somebody's life on the line because you think it's going to be cheaper to burn it off than it is to figure out how to transport it out.
Well, but that's the famous Ford Pinto case, right? And we talk
Yes.
about this in the Law Unscripted in our materials there as we mention this case, is that Ford, there's this smoking gun of a memo where they knew that the Pinto was likely to have an explosion if it was in a wreck based on the way that the gas tank was. And there was this memo saying, well, based on the calculated risk for paying for these wrongful death lawsuits versus the people, how expensive it would be to change this in the cars we already have, we're going to go ahead and pay for people to die, is essentially the gist of the memo. And it was this huge case. It's many of the seminars I've gone to throughout the years, even for continuing legal education classes, especially in our field of personal injury, it's a monumental case, this Ford Pinto case. So it's a question of knowledge, is when the parties who have dangerous materials, whether it's a Ford Pinto, a poor design, right, a product liability case, do the companies know that their drug, that their material, that their design is flawed, and if it continues that it will cause harm, possibly to the point of death? It's an intent crime, right? How much did they know and how much did they decide based on their knowledge to continue with their actions, with this false advertising, with the production of this poor design? And that, I think, is a proper place for the criminal field as well as the civil field for product liability claims.
Throw in your legal Latin here.
Which one? I have
mens rea.
Mens rea,
right?
yes, the intent. So there's the actus rea, which is the action. So in this case, it would be the products are sold, right? They actually are affirmatively sold for profit. They're put out into the marketplace. But the question in a criminal field is, well, what about the intent, the mens rea? And in this case, if the intent was to sell their product to gain a profit despite knowing that it was an extremely harmful and addictive product that could lead to death, what was their knowledge at the time? And I think that this case for the Supreme Court allows the states and the federal government to pursue that as an option against this company or others who were manufacturing drugs like OxyContin. Now, as someone who has been through multiple surgeries and extensive health issues, I am grateful for those medications. And I know that many of us who have been in extreme pain throughout our lives are grateful for it. But the question isn't so much how is it being used for good, but how are they using a good product for bad or for addictive purposes.
And if you're marketing something as not being addictive and you know that it is, that, I mean, many people would suffer pain rather than take the chance of being addicted.
Absolutely.
they
Or
think-
take less at a time. You know,
Right.
their
Right.
behaviors may be altered. And that's the idea now of anyone who uses these drugs now. It would be surprising if they don't know that these drugs are addictive. So it's the warning labels, right?
Yeah.
It's the idea of, can you market a
Well, and the
product like
marketing in
cigarettes?
general.
Exactly.
Yeah.
Cigarettes are out there, but they say, warning, nicotine is addictive. Vapes, there are all these products. They say, okay, you can still
It's
market
another class
it.
action right there. The Juul
Yeah.
class action was huge.
Absolutely. But are they putting profit above everything? Are they doing a fraud, committing a fraud on their audience? And I think that's
Yeah.
the big question of, yes, there will still be people who become addicted. But how much knowledge do they have, and what individual choices can they make based on the warnings, the proper warnings that are provided?
Is it informed consent, essentially, right? Like, you're buying
Yes.
this product. Are you at least being warned? I mean, you can do it. You're an adult. Like,
Well, and
it's a
your
free
doctor
country.
especially.
Exactly.
The doctors are prescribing, and they were, I think, many of them prescribing in good faith. Hey, we have this
Yeah.
wonderful painkiller that isn't addictive. That's what they
Right.
thought.
Yeah.
And if
Yeah.
they did, I mean, you wouldn't prosecute the doctor in the case
Unless you
where
know that
they did not have the mens rea to harm. They were there to help.
Right. Yeah, I think I'd be taking more of it if I didn't get so sick to my stomach. The good Lord knew that in order to protect me from addiction, that he would decide to make me throw up every time that I took such medication. So that's my own personal, prevention.
Twinsies. I have never had a serious need for a painkiller, but I am a klutzy girl. So at one point, I sort of cut my finger pretty severely and had to go to the ER. And they gave me a very mild painkiller. I could not take it. It also made me ill. So I guess we're just not the lucky ones out there.
So
Or maybe we are.
You must not. I thought you had watched the presidential debates the other night. And you didn't need a painkiller.
That's what the wine was for? Yeah.
It's called Xanax.
Yes. Okay.
Yeah, it was funny. I had one of my friends was like, I think I'm going to take a Xanax or a Klonopin tonight just to get through. I can't blame you.
Yeah.
All right. So
Ooh.
with that devolving, let's head to our last main case for today. Let's talk about the social media. We've got a case. There are two social media cases that have come out of the Supreme Court for the June 2024 decisions. The one today we're going to talk about is Murphy versus Missouri. So now we're talking about Missouri, Dr. Weil,
Okay.
rather than Idaho. But for
Yes.
this case, as I understand, there are two decisions for social media. You've written an article on this case. Is
I
that
have.
correct?
And if somebody's interested, it's if they go to the free First Amendment Encyclopedia, which is online at MTSU, it's under Murphy versus Missouri 2024. And it's basically an extended brief of what happened and what the court decided in the case.
And what are the facts? Because this is the one I like this case because it goes back to we're dismissing it for lack of standing. And it's one of those great decisions that seems Wait. So they did or didn't decide anything, and a lot of people don't understand what is standing? Why would it be dismissed for lack of standing, and what does that mean?
So if you look at Article 3 of the Constitution, it delineates the jurisdiction of the court, and it does so by talking about what cases and controversies it's supposed to decide. And essentially, over time, this has come to mean that the Supreme Court, our courts generally do not give advisory opinions, and they don't give an opinion. If I'm opposed to something happening in Idaho, typically I don't have a right to intervene in that case unless I'm directly affected. So there are all kinds of indices and tests that are used, but basically you have to show that there are at least two people who are in direct conflict with one another on a specific issue that's going to result in monetary or some other kind of damage.
For them, not somebody else, or not
For them.
potentially.
Right. So this comes out of the COVID-19 crisis. And I think understandably, the Surgeon General, and that's Murphy in this case, he was very concerned, or I believe it is. Do I have the parties identified correctly?
Chelsea, you're the one I think with possibly the case up. Can you tell?
Yeah.
Yes, I do. And that is clicking over that tab.
You guys,
Lord.
it's hard to do a podcast.
Yeah. Okay. Surgeon
It is,
General
yeah.
Vivek Murthy and others
Yeah.
would call or contact social media companies and say, why are you publishing an article that says vaccines are ineffective? Why are you publishing an article that says vaccines lead to heart attacks among teenage boys, et cetera, et cetera? And the question was whether this is an is this undue governmental interference with free speech? And the government essentially says, we're not telling them what to do. We're just saying, please keep the public interest in mind. And
so it's not a governmental mandate.
Right. And others say, well, that's easy to say, but I think the most interesting thing Alito says, I believe it's Facebook, got fined. Now here I'm going to they had lost $5 billion in a civil penalty case dealing with data privacy. And they're saying in a case where the government can level these kind of fines against you, is it reasonable to believe that these suggestions aren't in fact commands? That the government is actually dictating the content. They're not saying they're dictating it, but we also know that the government has threatened antitrust suits. Think of the millions of people that are on Facebook, and maybe that should be divided between them and some other companies. So with these threats hanging over them, is this free speech or not? But the case hinges on who's challenging the law. And the people and who's responsible for the content of the internet? Well, the government didn't. What happened is when the government contacted these companies, and maybe even before, they had their own rules about what they would post and what they wouldn't. And at least the more extreme claims, they typically would either not post or they would, there's a term for it, and with your age, you're going to know it better than I am, but we're not going to give as much prominence to this story in your searches as others. So we're going to move it down. So it's not, the first thing you see isn't, 3 teenagers die in Pennsylvania because they've had a vaccine shot. But the court essentially says, you're suing the government, but the government is not the one who took these down. And we honestly cannot tease out what would have happened in the absence of governmental intervention. You're not suing the right people. You need to sue Facebook. But of course, the problem there is, Facebook doesn't have a First Amendment obligation. Well, it might
allow speech,
not directly. It doesn't. It's not a governmental entity. So it's not prohibited.
I think that's the most important part, right? Is a lot of people think free speech is anything, for everywhere, for any action by anyone in any.
Congress shall make no law abridging freedom of speech or press.
Exactly. So the issue is
Congress
government.
Generally, national government.
Right. Yeah. So the constitutional rule is the government shall not suppress your speech, but that does not provide for private companies. So private companies can.
Now, here's where I think tomorrow we may have another discussion, because I believe that there are some state suits that are going to be settled probably on the last day, July 1st, in which states have tried to force social media companies to keep up content where the social media companies say, we don't think this is true and we'd like to take it down. And they say, no, you have to uphold free speech. So we will get a second social media case probably this Monday, and it'll probably take second or third place to the discussion of presidential immunity.
Right.
But wise listeners will be waiting for both of these cases and not just one of them.
Absolutely. Now, Chelsea, this one specific to, I believe it's X, the company formerly known as Twitter?
I believe so. Yeah, don't quote me on it, but I believe it was specifically Twitter.
Mm-hmm. And so ultimately, I think, and I want to get your opinion on this. So it was basically a dismissal of the case if nobody has standing. But what do you think the implications of it will be?
These are not my favorite type of cases, but I'm fascinated by these because I think the conversation of what is a platform like Facebook or Twitter and how do you even begin to moderate the internet, I think is a question that it is very prominent and will continue to be prominent. And that there's going to be a continued discussion with privacy. And I think also the question of like, how do you even define speech that's untrue, or does it have an untrue implication? Like, I think these are very difficult things to put parameters on.
And, there are two other cases that relate to this in the works. One is a law which is requiring TikTok to be divested from
China.
The company is BYTE. I think it's Byte.
From
in the next year.
From a Chinese-owned company, and whether the government can do that. It seems like there's another.
Well, there's the one. There's the
there's
Pfizer
a law.
case.
I'm sorry. There's a law at issue, which, as I understand it, we remember we had a case a couple months back where the Facebook or one of the social media companies was being targeted because the claim was that somebody had gotten inspired through seeing Facebook to commit a terrorist act, and whether they were responsible. And so part of this comes down to, it's sort of the question, is Facebook or these media companies, are they the same as telephones?
Right.
If I made a call to have somebody assassinated on the telephone, you wouldn't typically hold the telephone company responsible for that.
Right.
It's an
and to
avenue
what degree,
or means of communication.
Yeah. Who's responsible for what appears there?
And if they are responsible, don't they get to shut it down when they want to shut it down? I think that's the flip side of it, right? If we make these companies responsible for these things, then they kind of also get the choice to moderate them in the way that they see fit.
Right.
Right. And Chelsea,
it's going to be a tricky case. It's one of these new, remember when the telephone was first invented? Well, even through the 40s, 30s, I guess it was it Olmsted? One of the early cases, the court said police can engage in wiretapping as long as they don't commit a physical trespass on the phone.
Oh, yeah, this is a Fourth Amendment case.
Right. And then the court later came back, Katz, I believe it was, Katz versus the United States, where the Supreme Court said,
sounds right,
the Fourth Amendment is designed to protect people, not places. And it doesn't matter whether there was a physical trespass or not. If you're listening into somebody's telephone without their consent, this is a violation, particularly if government does it, is a violation of the Fourth Amendment. So we're in that area where we're still trying to figure out, and especially the people on the court who, believe it or not, mostly are older even than I am. I
you're up for president.
When I have a problems with computer, I go down the hall, find the youngest person that I can, and ask them to help me, and they usually can do it. Might be a 4-year-old,
right?
But you have a generation that hasn't grown up with this, trying to figure out the implications, and maybe that's a good reason to have law clerks who are usually recent graduates of law school, and they probably are fairly savvy about these things. But I'd like to be a fly on the wall and listening, now what exactly is TikTok? What's Facebook? What's a tweet?
What is an algorithm
here? This is funny. I actually think it's good to have perspective of people who did not grow up with this.
Yes.
Because I feel like it's very hard for me to conceptualize a world without the internet. Like it's very hard, right? Like I've always been able to Google something for the most part of my life. And so I think, and then the conversations I've had, at least with people in my generation, I don't know how you moderate something like that. That to me is like asking, a company to, or like, it would be like, to me, it's like asking Walmart to monitor every single person who buys something from any of their stores and what they do with those items on a mass scale. And it's like, can you do that? What is the expectation of a privacy if you're talking about your Facebook page, but you have a public page, or it's in the DMs. Like, even just in that small, like, I don't know how you do that.
And I
Someone's
grew
smarter
up,
than me.
I grew up in a time of party lines. And one of my
What?
dear grandmother's party
Wait,
lines.
what is that?
Okay. So
Am I
the
dumb?
phone
Should I
would
know
ring,
this?
and it
The way
would
you
have
made me.
different rings. You'd have 5 or 6 people on the same line. And
Okay.
so if it rang once, it was for you. If it went ding ding, it was for your neighbor, etc.
Okay.
And my grandmother routinely would come into the neighbors. She'd listen in, and it wasn't that uncommon to have a third party say, you'd say, "I wish I had that recipe," and they say, "Oh, I can provide it for you," or whatever.
So funny.
Oh, this
And
is a dream
so-
come true. As a nosy gal, can we bring this back, please?
Well, it works both ways. People can hear you too. So
I
be
get on the
careful
internet
what
and
you
tell my
wish
own
for.
business. So I love that's cool. Wait, so like, I didn't know that was a
Your
thing.
mind
That's
is
fascinating.
blown.
Particularly for older people, and I'm not trying to use stereotypes, but this was my grandmother's. This was one of her ways of keeping in touch with her neighbors. You
Yeah.
just listen in on their phone calls.
I mean, that's the
funny.
modern equivalent of I will go scroll through somebody's Instagram. I haven't seen what they're up to for a while. Like, let me just go through their stuff. What are y'all
Yep.
doing?
Yep. Anyway.
So let me make 2 quick comments. So I think Chelsea's from earlier that I want to swing back to is the question of truth, right? Is how do we determine and how do the courts determine what's true and what's not? With all this fact checking for the debates and what people say, ultimately what we're dealing with in this social media case is, as Dr. Weil said, this is a COVID-19 issue. Right? It's a
Right.
social media case, but it's revolving around what has happened with COVID-19. And the question of is, even Fauci is being questioned now. Oh, is what you were saying true? What truth was there? What extra notice? It's kind of like the other case we were talking about with the opium and asbestos, et cetera, is with the vaccines that have been pushed. Were they safe? Did you know they weren't safe and you were pushing them anyway? There's the new case that's been done for Pfizer. That Pfizer has been sued by Kansas officially for submitting untruths regarding their vaccine in order to push it and to make money, whereas it was actually harmful to the American public and to people in general, right? We're talking America
That's the
since we're
allegation.
here. Exactly.
But
That's
that
the
comes out to what you knew
allegation.
and when, because even
Right.
if those allegations are proved to be true, like I'm positive there are plenty of medical professionals on the internet, even on their own personal pages, saying, "Hey, this is great. You need to go get it," and with truly no ill intent, but they still did it, right? And I think, especially with medical stuff, I don't know, maybe I'm a little more woo-woo, but like I feel like I could go with the same symptoms to 5 different doctors and get 5 different diagnoses. Does it make any of those less true, right? Like who gets to be the arbiter of what is true in situations like that, which is very.
But
By
I
the
think
way,
it
one of
goes
the
back
fascinating
to
things to go back to our earlier discussion in this case dealing with, now I'm going to pull a Biden here.
Oh,
Look
no.
with Bright,
The Chevron case, yes.
right, is Alito has this notion that there is one best interpretation to a law, and we ought to apply that. And the people who
Yes.
are best able to do that are judges, not administrative agencies.
Yeah.
But is he right? I mean, is there always one best interpretation? And who does have, I can see if it's a highly technical issue, how you might claim that it's the administrative agency, but maybe when it comes to what does the law actually say, I think the court does have sort of a premium on being able to do that.
Yeah.
Yeah.
Well, I think with this Pfizer case for the COVID vaccine, I think a lot of that is going to be very similar to this Purdue Pharma type of case of what did they know and when. So if prescribing the opioids, it sounds like a lot of the doctors didn't, they were being marketed saying that it's a safe product. So the doctor shouldn't be liable, but the pharmaceutical company should be. And I think that's where we're going to get into the COVID issues for what I think is the first time, right, with this attorney general who's suing in Kansas of what was known, like you're saying exactly, Chelsea, what was known and when. What was disclosed to the public, what was not disclosed to the public? What did you know and you withheld? Did you cover up anything? So I think we're going to be seeing that coming up. And I'm very open-minded on this. I think overall, my own opinion is people have done the best job that they could with the information that they had at the time. As far as individuals, whether they accepted the vaccine or didn't do the vaccine, whether they did the mask mandates or whether they did not do the mask mandates, I have a lot more generally applicable grace for everybody. Of this is a different time, a very scary time where people have a lot of different opinions, and there isn't a lot of expertise out there on the issue. But
I heard somebody say this is
fascinating.
Oh, so sorry, Virginia. I didn't mean to cut
go
you off.
ahead.
I heard somebody say sort of what we saw happening with COVID was like the scientific process happening in real time of like, we have this hypothesis that this is how this is spreading. That's not accurate. And I think
it was based on the last one, which is 1918.
Right.
Right.
This is not a common event.
Pandemic.
Right.
Yeah.
And so I thought that was like, and I think I have a lot of grace towards that as well. I mean, there's people who don't trust medical professionals for whatever. And I mean, there's a lot to me of complex layers. So the grace with it. And it's like, yeah, I don't think most people are out there trying to spread misinformation or hurt people. I think people who had very strong stances or opinions were trying to promote what they thought. I don't think people are doing it with the intent to like, let me get everybody sick and make them die. Like, I don't think anybody was doing that for the most part.
Yeah, it just produces a lot of strong feelings. So it will be very interesting and fascinating to me and to us as legal professionals and in the legal field as to what comes out through discovery. What comes out through this court process? What memos? Will there be another Ford Pinto memo? Will we find something like that says, yeah, we know this, but we're going to get money. Let's put it out in the public. I'm fascinated. I think, we've gotten, goodness knows, I'm no medical professional, but we've gotten to the next step in this process. And for the U.S., it's a legal process, right? So that's where we are now, is into the courts finally with this. Hopefully some information will be brought forward where we can do a better fact check for everybody involved. What are the facts? What will they show? And there's a lot of, second guessing, as hindsight is 2020, of what did people know? When did they know it? And what do we do with the information that we have now and going forward? So that's what we're going to look for. I want to do a quick shout out to our two super fans. And Dr. Vile and Chelsea, I don't know that you know this, but we've got two that consistently comment and interact with our program on YouTube. And I want to say a thank you to them.
Do they need to raise their pay?
Yes, absolutely. Just as we're raising our own, right? 0 times 2 is still 0. So we've got Jay Savage is one of the handles with the LOL, quite a few of those, and Michael Sharp, 4217. Those are two constant contributors to comments and who seem to be listening quite a bit. We want to say thank you for listening. Thank you for engaging with us. I'm the one responding to comments, and I'll say I'm behind on it, so please forgive me for lack of a quick response and some response at all. I'm trying to keep up with it amidst all of our other regular jobs, but we do appreciate you listening, watching, and engaging with us. We're going to try to keep that going. Feel free for Jay Savage and Michael Sharp and others, please feel free to share these links in this show for others so that we can have more engagement. We believe that we're offering a good service. We enjoy doing this show and helping people understand the legal system and what laws are coming down. It's important for us, and hopefully you all are getting a good take on it, a better understanding of what's happening out there in the legal world. And we are trying to keep up with the hottest legal topics. If any of you figure out that there are some we've missed, please let us know. And Dr. Vile, I see you raising your hand.
Did we miss one? Did we promise to talk about Oklahoma? We can do it quickly.
Yes, we've got... Yes. So we've got two different things out in Oklahoma. Thank you. We've got Drummond, which is the state aid to Catholic schools, and the AG's announcement of teaching the Bible.
Right. So
yes,
let me just steal, and I'm hoping to get an article on this up on the First Amendment Encyclopedia too. It's Drummond versus Oklahoma Statewide Virtual Charter School Board. The state Supreme Court has struck down an agreement that Oklahoma was going to make with the St. Isidore of Seville Catholic Virtual School, in which they were going to directly support their educational mission, even though part of that mission is evangelizing, having mass for their students and the like. And the majority has struck it down. as a violation of the Establishment Clause of the First Amendment.
The separation
fairly
between
strong-
church and state.
A fairly strong dissent, which says this is not really very different, and I think that it is, by the way, but they say we don't think this is much different from giving vouchers for use at parochial schools. The court says there's a difference between parents making a decision as to how to use tuition and direct support for a Catholic school.
Yeah.
But
Sure.
this will almost surely get to the U.S. Supreme Court.
Oh, it has
And in the meantime, the Attorney General of Oklahoma has announced that grades 5 through 12 will teach the Bible in public school classrooms.
Right.
Now, this is, remember, just last couple of days,
Ten
we talked
Commandments
about
in Louisiana.
a state, right, Louisiana deciding that we're going to post the 10 Commandments in each class. I do not know how that case is going to go, but I think the notion of a secular institution teaching my children or anybody else's children the meaning of the Bible is likely to fall afoul of the Establishment Clause.
Right. Why wouldn't
And
we
also,
be
like,
forced
which
to-
version? Like, who?
Exactly.
Well,
I mean,
that's right. And this was a problem in the school prayer cases and Bible reading
Yeah.
cases. We're going to use the do-a-day, I guess it is the Catholic version. We use King James. We're going to use, Revised Standard.
And
And
if
even
we're-
just the way
portions are we
people
going to
teach,
select?
right? The teachings and interpretations. I mean, there's probably 10 churches within a mile of where I am. I could go in and hear a sermon on the same topic from 10 different preachers and get 10 different explanations on what that meant.
But
and
they're all
why
called
wouldn't
Peachtree,
we
right?
be Peachtree.
Yeah, Peachtree. No,
Church, first
you're not wrong.
Peachtree Church.
Oh, it's so
second
funny.
Peachtree Church.
and
Reformed Peachtree Church.
this goes back to the reindeer case. Is it going to?
Yes.
This seems very specific, religion specific, which seems to run afoul of the church, the state promoting a specific church or religion. Versus, why wouldn't somebody be saying, well, let's teach the Quran. Let's teach, something else is let's provide all of these religious, if we're going to have to teach Christian theology, let's teach the others.
And historically, what happens, and this is the reason we have the Establishment Clause, is the people that get left out are the minorities.
Right.
You're very unlikely to have too many Jehovah's Witnesses teaching in public schools. Outside of
Wicked.
Utah and Arizona, you're probably
I was about to
not
say
going to have
Utah. We
many
might get an
LDS
LDS.
teaching. So, and they might say, well, you really can't interpret the Bible apart from the Book of Mormon.
Right.
So I really think I think it's a step too far. But
Yeah.
remember Kennedy versus Bremerton, the football case, prayer. The court basically said we're no longer using the Lemon case, and we're going to use
Right.
history and tradition. And the question is, which history and tradition are going to use?
Whose?
Yeah.
So that's going to be interesting. And I think that's going to be coming up in the 2025 Supreme Court decision. So stay tuned with us as we hit those. We're going to finish out the 2024 season soon. Monday, we've got probably after you listen to this program, we've already reviewed the privileged immunity case, the presidential immunity case, as well as this extra social media case. But stay tuned with us, like and subscribe the channel so that you can be alert to other issues coming out, other podcasts coming out as we walk you through the rest of the Supreme Court decisions for 2024 and move on from there. Happy 4th of July, by the way, for those of you who are listening who don't watch our other programs. And we will catch you next time on the Legal Weekly Wine.